Part 6 meeting will now come back to order. Please be seated.
Thank you. We're back on the record. I guess next up would be Plaintiff Haley and Belstein's motion to strike UNF answer for creating and using fake whole food records. Is that correct?
That is correct, John. This may take some time, Your Honor. Your Honor, the next motion is plaintiff's motion to eliminate number 5 to pre-admit the standard life expectancy table for Kathy Ryerson. There was one opposition filed to this motion by Real Water, and really the opposition essentially is, well, we don't know that she would have, that the life expectancy table would accurately reflect Ms. Ryerson's life expectancy. And that I don't think is at issue here. All we're asking is that the tables themselves be pre-admitted. This is a pattern jury instruction. You know, should Ms. Ryerson die, she has heirs who are claiming wrongful death damages. Her life expectancy is clearly a relevant issue related to the valuation of those damages. There's a Nevada pattern jury instruction, 5.8 in the 2018 edition, that specifically provides the life expectancy table, and it specifically says that this published information is evidence of how long a person is likely to live, but it is not conclusive. So all it is evidence. They're not waiving any right to challenge it or to say that she would have lived, you know, less or more than what the life expectancy table shows. It's just evidence. It's clearly relevant. It's government CDC published tables. It's allowed by the pattern jury instructions, so we ask that the life expectancy table be created.
Your Honor, Joel Odou on behalf of Blue Water. I'll be very brief. The motion changed from when the motion was filed and the reply brief. In the motion, it was to admit Kathy Ryerson's life expectancy table. They were going to say, this is her life expectancy table, not this is the life expectancy table, which is what they would put in the reply brief. And as we pointed out, if somebody is going to say this is her life expectancy table, they need to lay the foundation. They need to set forth the facts why it applies to her. And that was the, I guess the result of our opposition was they changed what they're asking for in the reply.
Sir.
The pattern jury instruction references the CDC published life expectancy tables. That's
I don't mind saying this. I can't remember any time in 17 years I've excluded a government prepared life expectancy table. They come in. I will say this though, and of course, it has to be relevant to the case. Last but not least, I'll just put everybody on notice of this because I noticed the pattern jury instruction that was utilized. I don't use that. If it's not in the 1986 book, I'm just going to tell you right now, then we can look to other sources. But in the general sense, I think the loose leaf binder jury instruction, pattern jury instruction book, there's been issues with that. I'm not saying I don't look to them at times if we don't, because I do understand the 1986 Blue Book is somewhat limited, but in the general sense, it has some pretty good tort instructions. It doesn't cover contracts and a lot of different issues, but that's my go-to. And in order to convince me, and I'm quite sure they have a life expectancy table instruction in the 1986 book, right? And the reason why I bring that up, that's the only book that I'm aware of that was approved by our Supreme Court. In fact, wasn't a forward done in that book by one of our Nevada Supreme Court justices. I don't have it in front of me, but I could get it in 10 seconds because I have a copy. And if you need it, I don't mind saying this. If you don't have copies, we can forward you copies of all of the instructions along with the table of contents. because we have. On Word Perfect, I think. I don't mind telling you that. And I can get them to you, and you can get it in this type of form, but I have them all available for you in case you don't find them. Because they have been told, and this is important too, because we actually, I think we have download, I don't know how we did this, but the table of contents, which are really important for that. So we just won't give you the instructions, but we actually have the table of contents. That's my understanding. But if not, we can make copies of it, because I think that does help. Any questions on that?
No, we appreciate that, Your Honor. I think it comes up later as to where the jury instructions were being proposed from.
Right. You know, but 1986, and I'm not saying, I mean, for example, if we don't have a jury instruction in that book, or for exam, that doesn't mean I won't look to the other version, but I want to make sure that it's correct as far as the law is concerned. Everybody understand that? And I'm not saying I don't go to other sources too. It all depends, because unfortunately, even the binder, what year was that, 2000? Anybody know?
18, Your Honor, I believe.
No, I don't think it's that new.
No, I thought it was 94 timeframe, or
Somewhere in there, but it doesn't matter. I'm not saying I won't look at that if it's not covered in the 1986 version. Just as important too, if you don't like the 1986, you're gonna have to prove to me why. You don't, I don't mind telling you that. You're gonna have to show me why. It's not good law anymore. But I think those instructions are really well written. They're straightforward, they're simple. And, but I would anticipate it's not gonna cover all the issues in this case. I know it's not. But that's another day.
And I appreciate that information, and then that's exactly why we filed the motion. Instead of relying on any jury instruction or pattern jury instruction, we just seek to pre-admit the table. It's the CDC published table. We can look at the 1986 version to see if they reference the same.
Well, make sure, I'm not a betting man, but based upon using the 1986 version, it does, in all probability, have a life expectancy table jury instruction. And that just goes to show you that that's pretty standard, because we're talking about 1986. How many years ago was that? Long time. Yeah, it's a long time ago, you know, but anyway.
Okay, so as I understand, the motion's granted, and if there's any issue with the table, we'll.
Well, it's, I want to make sure, yeah, it's granted as far as the life expectancy. This isn't the, yeah. It's granted. Let's move on to the next one.
The next one in order is plaintiff's motion to eliminate number 6 for judicial notice on the conversion rate between the Romanian RON and the US dollar. That was not opposed, and we filed a notice of non-opposition on that one. So the premise behind it is that the meters were manufactured in Romania, and in terms of the cost versus US dollars, we think is relevant to different issues, including motivation and motivation on some of the actions of the meter defendants, and so that's why we requested judicial notice on the conversion rate, and again, that motion was not opposed.
The only thing I would just add, Your Honor, not in opposition to it really, is that the date at which this motion was filed and the date at Wheels Start trial, the actual exchange rate may vary. And so we would just ask the judicial notice to be taken on the day of the trial. I don't mind if they tell me what it is, but on that day, I think it's more relevant to what it is than what it was maybe 2 months before this.
Sure.
I don't think it makes a big difference. We looked at the exchange rate, it seems to be pretty standard despite the interest rate raises in the United States. So if Mr. Rasmussen has one today at trial or 10 days before, just tell us what it is. So
We'll do it.
All right. Granted. And we'll do that, make sure you note that in the order, sir.
Thanks.
You have the opportunity to supply a more current exchange rate. Okay, so where do we go next?
Number 7, Your Honor,
All right, let's talk about
moving right along. This should be pretty straightforward, Your Honor. It's a motion to eliminate to designate Blaine Jones as a speaking managing agent on behalf of Real Water. Your Honor, unless you have some questions on this one, we've talked about Palmer already, we've spoken about NRCP 32A3 in particular. You're so familiar with this concept, and I've seen and heard you make decisions on this motion in other cases. I know the court's familiar with the law. In terms factually, Mr. Jones was the executive vice president of Real Water for 15 years. He is the son of the owners, Brent and Amy Jones, and he was also designated as a PMK witness on behalf of Real Water. His deposition, do you have a deposition, Shane, available? Volume 1, dated January 12, 2023.
With the video or the transcript?
The transcript will be fine. I think it'll take longer than the video. If you could go to page 21. Line 20, I believe, is where relevant testimony comes in. At 21. I'm sorry. Yeah, it starts at the bottom of 21, line 20, goes to 22. Go down further. Go to the top of the document, let's make sure we're on.
This is the second.
No, this is the second one. I need the first one. January 12th, 23. So, Your Honor, first he's been designated as the PMK, and it says right there, go back to the first page. It says right under the heading, Blaine Jones is PMK for Real Water Inc. Now go to page 21, line 20. And this is where it starts out by identifying Exhibit 1 to his deposition, Your Honor, which is the 4th amended notice of videotape deposition. Go down, Shane. And it says, as he's appearing as a person most knowledgeable for Real Water, have you seen this document before? I believe so, yes. And then go down a little further. Stop right there. Do you understand that you're here today to give testimony on behalf of Real Water with respect to topics, the 2 topics listed on the deposition notice? Yes. Your Honor, I think that's sufficient information for the court to grant this motion. In terms of the opposition, Your Honor.
I want to make sure I understand the background. Was this a 30B6 deposition?
It was, Your Honor.
And
And,
those were, and their topics were listed.
yes, Your Honor. And, Your Honor, one thing I will say, I think Real Water of Tennessee filed an opposition because they were concerned. We were asking Mr. Blaine Jones to, seeking that he be designated as a managing speaking agent for Real Water of Tennessee. I don't believe that's what we're doing. So that should allay his concerns, I believe. And he's shaking his head affirmatively, Your Honor. Jim Cavanaugh.
If you're stipulating that you're withdrawing it as to Real Water Tennessee.
Yeah, I don't believe he is the son of the owner of Real Water, Tennessee. Nor did I believe was he designated as Real Water. Let me make sure, if you're saying, hold tight.
Yeah, you remember this Real Water Tennessee issue comes up in the summary judgment motion. Our position is Real Water Tennessee really should be part of the first phase because we haven't sued Real Water Tennessee. So that's why we didn't file a motion to designate him as a managing speaking agent. So he's both the PMK and he's an officer, not a Real Water Tennessee. Maybe he is, I don't know. But he's an officer of Real Water Inc. And so that's the basis for the motion.
So, I was right, Jim. having read the reply, it certainly didn't say we were naming him as your managing speaking agent. So, Your Honor, I think that addresses his opposition. The only other
Just for the
opposition,
record, we're making sure we're talking about, I just want to make sure I'm clear on this. Infinity Lifestyles Inc., a Nevada corporation, DBA Real Water, and then we have Real Water Inc., a Delaware corporation. Is that right?
correct. And the only other opposition, I think,
We'll listen, go ahead.
centers around Mr. Blaine Jones ultimately becoming a plaintiff in a separate unrelated case. I use unrelated perhaps in quotation marks. But in a separate case, and his claim was brought a couple of months after this deposition. So the termination of PMK and the termination as a managing speaking agent is made at the time of deposition, not 2 months later on. So my belief is that opposition is not well taken. Your Honor, and given everything that we've already discussed, his position at the company, as well as his designation as a PMK, I believe the motion should be granted.
Okay, thank you, sir.
Thank you.
Mr. Odou, sir.
Thank you, and I'll use the podium. I might
No,
have a
absolutely.
few things to say. So, Your Honor, I think the funny part about this is, the designation, the plaintiffs argue, oh, he's designated as a PMK, therefore he can talk about everything.
Well, no, I understand
Not accurate.
the limitation of 30B6. I get it.
And the
Topics.
limitation in this case, Your Honor, it's incredibly narrow. Let me give you some background as to the limitation. Blaine Jones testified, he was deposed twice. He was deposed in his individual capacity and he was deposed as a 30B6 for 2 topics. The manufacturing process of real water, the manufacturing process of the real water concentrate, including but not limited to the ingredients, the materials used, the creation of the concentrate, and the process by which the concentrate is made. Those are the 2 only topics that were in the 30B6 notice. Those were the 2 only topics where he is the speaking agent of the real water defendants. Very, very limited. And the reason why it's very limited, and the reason why this is important, is Mr. Jones testified that yes, he was an officer of the company for several years. He was then tasked by the company to do the move. Because the move was such a strenuous process, he resigned his other duties at the company. So at the time that Real Water left Desert Inn, he had resigned as a vice president of the company. And his role was 100% dedicated to the moving of the company to 2 places, Henderson and Mesa, Arizona, and setting up the operations in Mesa, Arizona. Blaine testified extensively about how difficult it was to get 2 different places set up. And as the court's well aware, a lot of the facts and a lot of the issues of this case concern what happened in the summer and fall of 2020. And that is after Blaine Jones undertook the obligation to move the company and was no longer trying to perform those other tasks for the company. Frequently, during his depositions, he said, I don't know. You would have to ask Brent Jones that question. You would have to ask Brent's wife, Amy Jones, that question, because I do not have that information. So as you can see, Your Honor, our concern is the plaintiff saying, oh, well, he's the speaking agent. If he doesn't know, therefore Real Water doesn't know, and that's not true. There are many times when he deferred to Obed Penalosa, he deferred to Mike Bush, he deferred to Brent Jones, he deferred to Amy Jones. So as far as him being a speaking agent, yeah, he is the one who made the concentrate. He has the personal knowledge. He was educated as a 30B6 witness as to the concentrate, and that's the limits of what he can testify to intelligently in this case. The motion, when they filed it, was completely unclear what they're asking for. They said, oh, he's a speaking agent. They cited the Palmer case. Again, the Palmer case is about discovery and not trial. The 30b-6, and if the motion is to enforce 30b-6, that's a discovery motion. It's not a motion on limine. His testimony is consistent with the two 30b-6 topics that he testified to. It's black letter law. There is no dispute that he didn't testify to one of those two topics. He testified to both of them at length. So the motion should be denied because they're asking the court to reaffirm what the law is, and the law was followed. Plaintiff cites no authority that now they can designate him as a speaking agent for all of these things that they allege happened after he was no longer even in charge of those aspects of the company, where he deferred to Brent Jones, where he deferred to Amy Jones. Yes, he can testify as to his 30b-6 topics, and yes, he can testify as to his personal knowledge. We've seen again, time and time again, where issues of, from the FDA or issues of investigation, they asked Mr. Jones questions, Mr. Blaine Jones questions. He gave answers. Yeah, he's competent to provide that testimony at trial, and there's no dispute over that. The only dispute that we have is they can't now take all the issues in the case and say, well, Blaine Jones doesn't know, real water is prohibited from calling another witness. And that's why this motion is improper. There were two topics in the designation. He testified as to those two topics. He will testify. He's been subpoenaed to appear for trial as to those two topics. He's been subpoenaed to appear for trial. He'll testify as to his personal knowledge of other topics. And that's really what our opposition is about. He's not speaking on behalf of the company as to things, for example, like marketing. You see the marketing video that apparently plaintiffs are going to be played in opening. Blaine testified that he didn't write the script for that video. It was just what was given to him and what was recorded. And so I think it's important to draw that distinction. It really is an improper motion because they didn't tell the court what it is they're asking. They just want to make him the speaking agent, apparently, for all issues with water. And we'll see this with other defendants, and it's improper for that reason. It should be denied.
Anyone else on the defense side wants to weigh in? Nope.
Mr. Parker.
Your Honor, again, I'm surprised somewhat that Mr. Odou would make the arguments he made given what the rule says. And I referenced this right from the beginning because the rule is very clear on this point. Rule 32A3 says, an adverse party, certainly where adverse to the reward, may use for any purpose the deposition of a party or anyone who, when deposed, was the party's officer. We've already had an admission here by Mr. Odou that he was an officer. As of today, last time we checked the Secretary of State's information, he's still a Secretary Treasurer of Real Water Inc.
Is that true? Is he still an officer?
The entity, Your Honor, Julie did for water, the entity has declared bankruptcy and is not functioning and has not functioned since August of 2021.
Judge, if you look up on the Secretary of State, and I think they moved it in Wyoming for some reason. If you look up on the Secretary of State, I did it last week, I haven't done it today. He's a Secretary and Treasurer of Real Water Inc. today, or as of last week. And I think, you know, we pointed that out in our reply, you know, that's why the statute says or. If he's an officer, or. It doesn't say he has to be a PMK and an officer. It says or. So the mere fact he was PMK.
Well, there's no question, is, for the record, is disjunctive.
Right. Exactly. And I didn't even get finished,
And
make a chance to finish the paragraph.
I was trying to answer
Mr.
the
Kemp's
court's question.
That's fine, I'm not blaming you. Mr. Kemp stole the rest of my thunder, that's all right. Go right ahead. Go ahead, Joan.
Your Honor, the company went out of business when it declared bankruptcy. Originally, they were going to resume business. They quickly decided they were not. There have been no corporate acts other than to further the bankruptcy. So it doesn't surprise me that the company has not done anything in terms of filing officers because they're bankrupt with no intention to resume operations. Thank you, Ted.
No worry about it, Mr. Odou. And if that's the truth, Your Honor, the last time they did update the annual officers and directors, which was required annually, he was a secretary and he was a treasurer. Again, the paragraph continues. When deposed was the party's officer, which he was then and is now, director, managing agent, or designee under Rule 30b-6, which is where I started with the deposition.
Or 31A4.
Or 31A4. Correct, Your Honor. There's nothing that Mr. Odou said that changes this rule or the impact of this rule on the court's decision. I ask the motion be granted, Your Honor. Oh, one other thing, because Mr. Odou did mention this, and I think this is a concession on his part, wittingly or unwittingly. Blaine Jones was the contact person for all of public authorities' investigations, CDC, the FDA, and the Southern Nevada Health District. He's not a managing agent handling that type of responsibility. You know, I don't understand how they would appoint him to do that, such an important role in such an important investigation if he wasn't.
And just to be clear, Your Honor, we're not arguing that we can't ask him what happened during those things, because he did participate. It's his testimony. So I think we're still saying the same thing. The bankruptcy came after that. He resigned, though, well before that. As far as things that he's got personal knowledge of, I'm not objecting to.
But here's the thing, and this is really, really important, because I come back to the, is he still being listed on the Secretary of State as an officer?
I would assume so, because they have taken no action at all after the bankruptcy.
And here's kind of my point, because at the end of the day, and I know I don't mind, as a trial judge, I have certain thoughts. For example, there's certain secondary sources I do respect. And for example, when counsel cites Wright Miller, I really like Wright Miller. I wish I had the treatise, but we can't afford it. I have Morris Federal Practice and Procedure, because it's cheaper, and I rely upon it all the time. And so, for example, in here it says that Rule 32, the provisions of Rule 32 should be liberally construed. Now, I'll go down to another item that I don't give as much weight to, because I don't like unpublished decisions. I don't mind telling you that. And there's many reasons for that. Many times they're not vetted, right? You can't shepherdize them. And so, for example, and this happens from time to time, I'm trying to make a decision as a trial judge as to whether I should go as unsettled in Nevada. And if there's an unpublished decision from another jurisdiction side, I have a very low level of confidence, because I can't shepherdize it, right? Whereas hypothetically, if I'm going to another state, a sister state, and it's been shepherdize, I can look, oh man, this has been adopted by so many jurisdictions, then I can say, well, maybe Nevada should jump on board and do the same thing. And so I can't perform my traditional legal research analysis that I try to do. And I don't mind saying it, I give my law clerks a hard time about this, because I tell them, this is what I expect. But Mr. Odou, what do I say here? Because at the end of the day, we got Wright and Miller, it should be liberally construed. The statute, the rules, this is 32A3. It says, quote, an adverse party may use for any purpose the deposition of a party or anyone who, when deposed, was a party's officer, director, managing agent, or designee under 30B-6. And so from a factual perspective, it appears to me, potentially, when you talk about square pegs, round holes, this would be a square peg and a square hole.
And the reason why I argue it's a square peg in a round hole is he had resigned as an officer of the company well before his deposition, well before the bankruptcy. He had resigned in 2020 when the operations of the company were being moved. The company went out of business and did not correct the website.
But my question is this, though. Technically, when do you resign?
That's the issue, Your Honor. As a layperson, he believed he resigned when he told his father and his father's wife, I'm resigning. And you're right, there is nothing recorded with Nevada Secretary of State, because the company operations ceased shortly thereafter. and then the bankruptcy came after that, and then his deposition came. And so at the time of his deposition, he was not an officer in his mind. Now,
But my question is this, and understand this, I mean, this is important because there are specific wind down provisions as far as corporations are concerned. We kind of know that, right? There's a
Right.
process you go through. But my point is this, does it really matter what's in his mind? Because for all practical purposes, if he wanted to insulate himself from potential liability or responsibility somewhere down the road, I think that the first step would be, okay, I'm listed as a officer and or director for this corporation. I should make sure that that's amended from the Secretary of State perspective.
And the reason why I think it is important what's in his mind, Your Honor, this is really no different than any employee of any company putting. You know, you may have the president or the CEO of Disneyland, they say, as of today, I'm gone, I'm angry, I'm leaving the company. In their mind, that is their last day. And the court points out, until those filings are made with the SEC, with the secretaries of state, they're still listed. I agree. And what is the court to do with that? Well, I think it's important what's in the witness's mind, because the witness is the one who testified, I didn't handle that, I didn't do that. My responsibilities were taken over by Odou Penalosa. My responsibilities were taken over by, who was not deposed in this case, my responsibilities were taken over by Brent Jones, who was deposed in this case as a PMK of Real Water, Tennessee. And I don't want to get on a tangent, but Mr. Blaine Jones and Brent Jones were officers of Real Water Inc. Real Water Inc. owned Real Water, Tennessee, different issue. But I think it is important what's in his mind, Your Honor.
Okay, but I understand that, and that might be what is in his mind. But from a legal perspective, what is he required to do vis-a-vis third parties?
And I think the reason why it's important what's in his mind is because what we are doing legally is we are looking at the intent behind the law to bind the company. And we're looking at that an officer of the company, the theory is the officer of the company has a vested interest in the company. They're going to provide truthful and accurate testimony on behalf of the company. They're going to understand, and this is the key part, they're going to understand that their testimony is binding the company because they're an officer. When the witness doesn't believe they're an officer, they don't realize that they're binding the company. And I think that's the tension in the law between what the plaintiffs are arguing and what the witness believes.
May I address that, Your Honor?
Of course, you know I've vetted every issue, Mr. Parker.
Thank you.
Anything
I was
else?
finished. Thank you, Your Honor.
Your Honor, there's nothing in this rule that says or requires some type of psychoanalysis of the deponent before the deposition begins. So unless we're trying to rewrite this rule and add that component, I don't think that argument's well taken. What I think is even more important for the court to consider is the lawyer. Someone at Mr. Odou's office decided to select him as their PMK and to prepare him to be the PMK. So perhaps before they actually selected him and prepared him and brought him to the deposition, they should have performed that psychoanalysis. But since they chose not to, and they produced him and prepared him, he spoke on behalf of the company. Well, the rule is pretty plain on its face. I don't see how anything Mr. Odou has said changes the rule or should change the court's inclinations.
Well, I don't have any inclination, I don't mind telling you that. I look at it from this perspective, I really and truly do. And maybe I have a different view since I've been doing business court for about 4 or 5 years now, and not necessarily construction defect. And what's fascinating about business court, going in, I thought we'd have all these cases in water corporations, we don't. But I do understand what the corporate structure is under state of Nevada and what's required. As far as filings and all those types of things, and we also have a wind down mechanism in place, right? We do, as far as corporations are concerned. And here's my point. There's a reason why businesses or entities make a determination to incorporate. There are. With that incorporation goes certain potential protections, right? We can all agree. Just as important too, along with that incorporation goes duties and responsibilities on the board, on the CEO, and all those things. And so when I read the rule and understand this, I'm looking at the rule in this point. I'm just reading it. I don't think there's any ambiguity in the rule. And I'm just giving, as a trial judge, I have to give it its plain meaning. I think everybody understands that. And so when I look at it, and this is what the rule says. When deposed was the party's officer, director, managing agent. Based upon the evidence I have in front of me, it's fairly clear. Even today, he's listed with the Secretary of State as a director or officer. And here's my point. What if you had somebody that's listed at the Secretary of State as a registered agent, and they said, oh, I made a determination, I don't want to do that anymore. Well, they better go down to the Secretary of State and get pulled off as a registered agent for that corporation. Because if they get served and that corporation doesn't file their answer within the appropriate time period, they might have problems, right? And so it's kind of like, and Mr. Odou, the reason I'm spending my time, I just want to explain to you why I'm making my decision.
I appreciate that, yeah.
You know, I always do. And if I had some doubts, I would go back and read, but I'm just looking at the plain rule, and he was a director officer. And so I think in applying Rule 32, because what he should have done is he should have gone down to the secretary. He should have gone that next step and had his name removed from the board and potentially, and what that would have done is that would have insulated him and the corporation. And I think it's important to point that out. And I'm looking at this from a business court judge's perspective, because we have these and Nevada wants to be the Delaware of the West, right? And we do a lot of that type of work here in the state of Nevada. And I will say this, we have very complex corporate cases here. We have very complex LLC cases. It's like one case I had a shareholder derivative litigation case that settled. It was the 5th highest settlement in the history of the country. And I won't mention the case, but parts of it confidential. I don't think that necessarily is. But it just shows you the types of cases we have from a business litigation.
Start with the W you're on?
Yeah, oh yeah.
I think we all know.
But we deal with, and that case was really complex. Right, it was. There was a request for a special litigation committee, and I granted it, and I'm glad I did, because it helped resolve the case. You know, our recurrent metric and all that, that's another different animal I have to deal with from time.
Your Honor, I appreciate the ruling. I just want to make one additional point for the record.
Oh, absolutely.
And I appreciate that, Your Honor. Mr. Parker had alluded to that the PMK was selected by council. The PMK was not selected by council. The PMK was selected by Real Water, and the reason why Blaine Jones was selected is because he is the only one who made the concentrate. Occasionally he had somebody help him, but he is the only one that could testify as to the making of the concentrate. That's why he was designated by the corporation, not our firm, as the PMK.
All right. Thank
Is it
you.
lunchtime?
Yeah, that's what I was going to say, my court.
So just for the purpose of the record, John, that motion is granted, and then we'll start with 8 after lunch, John?
Yes, sir.
I was just saying, I mean, I've heard I have the next one, it's the same issue, except it's my witness. If we want to get out of here, we'll do that. I just didn't want to take my time to lunch for the 3rd day. So that's fine, Mayor, we'll wait.
So you can, I tell you what, if you want to leave it here, we can protect it, maybe we can put it in.
No.
You
I'm
can
just
give it to the
paranoid.
marshal.
I review during lunch, that's all.
Okay,
Thank you.
1:15?
Sounds great, John.
Thank
Thank you.
All right.
Order 16, town session officer. Please proceed.
All right, let's go ahead and set forth our appearances for the record.
Your Honor, we still don't have Miss Maria back.
Oh, all right, we shouldn't have come in, John.
Your movements are just following. You want to step down until?
No, we'll wait for it.
Yes, Your Honor.
And this doesn't have to go on the record, but as far as, there was a question regarding, a dispute regarding the jury questionnaires and potential hardships, right?
Yes, Your Honor. I think we were
Yes.
working towards narrowing that dispute so we can frame it for the court.
I understand. All I'm going to say is this, you don't have to give me copies of the jury questionnaires, I have all the originals. They've been filled
Oh,
out.
great.
Yeah, I have them in chambers, I have them in storage,
Excellent.
locked.
Okay, thank you, Your Honor.
I know.
We appreciate it. Thank
So,
you.
so when the time comes, I'll have the marshal bring all the boxes in. I think we have like 6 boxes right now. And there's more on the way. That's what they tell me. But
We appreciate it. Your
we
Honor.
secure them, so that'll be easy to handle. You don't have to go and print them for me. I have the originals.
Terrific. Thank you.
Thank you.
So anyway, let's go ahead and start with our appearance.
Hold on, just let me go on the record. I just wanted to tell you before we go on the record, IT's gonna come and help me with that issue. While
Who's
we're-
in?
Yes,
Okay.
so if you could just one moment. Okay.
It doesn't impact our recording, does it?
No, it's on the, we're on the record now.
Okay, let's go ahead and set forth our appearances.
Eric Pepperman for plaintiff.
City Partners for plaintiff,
Jim Neale for United Natural Foods, Your Honor.
Good afternoon, Your Honor. Joel Odou on behalf of Real Water and InfinityLifestyles.com. Sorry.
That's it.
So anxious.
Joan Anderson for United Natural Foods.
Rob Robbins, Milwaukee Instrument Team. Scott Rasmussen, Brittany Lyons for Hanna Instruments.
Afternoon, Jim Cavanaugh for Real Water of Tennessee LLC.
Afternoon, Your Honor. David Spurlock, United Natural Foods.
All right, once again, good afternoon. And tell me, where do we go next? What's next on the list?
We're on plaintiff's motion limiting number 8, Your Honor.
Okay.
That is 9.
This is regarding Mr. Brown, is that correct?
That is correct. That is correct. And the same legal arguments are at work here in this motion, Your Honor. The ones we left off with primarily previously dealing with the real water designation. So again, it's NRCP 32A3, and I have the deposition testimony of Mr. Jason Brown, Your Honor, teed up. If I could put that on the screen for the court.
All right.
So I'm concerned with page 22, I believe. Sure. Page 22, correct. Page 22, lines 4 through 12, Your Honor. And it just confirms that Mr. Brown, from 2018, has been general manager of Milwaukee Instruments. He agreed to that. He said, I was general manager from December 2019 through, today says he changed his mind, so excuse me, December 18th through January 2018. And my current title is operations manager. So you became the operations manager of Milwaukee Instruments in January of 2019. That is correct. He says, yes, sir. Attached to this deposition, which was taken on February 2nd, 2023, is Exhibit 17. If you could bring that before the court. And Exhibit 17, Your Honor, is Milwaukee Instruments supplemental responses to plaintiff's first set of interrogatories. And I would direct the court to page 6. If you could go to page 6 for me. In response to request number 4, response to interrogatory number 4, this is a listing of the employees for Milwaukee Instruments. Carl Savaggio, is president. Brian Moore is deceased. Jason Brown took that position as general operations manager. That's the thrust. I'm addressing the thrust of the opposition, that he was not a managing agent. Your Honor, there's only one person ahead of this gentleman, and that is the president. He was one provided for deposition, Your Honor, and I think given the rule that we've read before the court now, I think more than once, you only have to fit into one of the categories, and certainly he does in terms of manager. Unless the court has any questions, I'm not going to waste much time going back over the same law we've already discussed.
All right. Thank you, sir.
Thank you.
The interrogatory that you were just shown lists, it asked for employees for the last 12 years, I believe, something like that. It was a longer time period. So all the employees he lists on there, most of the people don't work there, and I think during his deposition, he even said that there were, I think at the time, 4 employees working there, in the office with him. One was the secretary, one, and I think there's a couple people that work in the back. In 2018, there was a general manager at Milwaukee, whose name was Brian Moore. He passed away in 2018. So they promoted Mr. Brown, who was basically in charge of the shipping stuff. He'd receive orders, package orders, invoicing out, take boxes out, that type of stuff. They gave him the title of the deceased person's job, which is general manager, in December of 2018, according to the deposition transcript. 1 month later, in January of 2018, they took away that title, and they gave him a title of operations manager. He is not an officer in the company, unlike Mr. Blaine Jones. He's not an officer, not a director. He is the operations manager, but he's not somebody that's gonna bind the company to the rent or a lease or anything like that. The president of the company is Carl Savaggi, and they have noticed a 30B6. It hasn't been taken yet. Mr. Savaggio will be the 30B6. He's the one that will be speaking for the company. Mr. Brown, when his deposition was taken, it was not a 30B6. There were no topics given to him. He was, without belaboring the point, because I'm sure your Honor is aware of it, he was 2 days back from being out sick for about 6 months. He was not admonished not to guess in his deposition, and we've cited some testimony where he clearly was providing answers, trying to give his best answer. That's what he was told to do. And that was, there's a question there about alkaline water and Kangen water, and then he says, yes, they're the same thing, or something like that. And then he states later on in his deposition, which we've cited in our opposition, that he doesn't really know what the Kangen is or any of that equipment is. He's never used it. Doesn't really know what it is. But in the end, he'd already provided an answer saying yes to certain things. So I don't know how to put this, but he's the guy who's kind of helping run the office and get the orders out, but he's not somebody that would speak for the corporation. He's not that type of person. His background was in retail. I believe he told me that he worked in sales at like a cell phone company or something like that, making like $9 an hour out there in the middle of North Carolina. And this job showed up in the paper, and he applied for it and got it working in shipping for them. And when Mr. Moore passed, they promoted him and then demoted him a month later from that general manager title that Mr. Moore had received, had before him. So he's not somebody that would be a managing speaking agent for this company. He's not sophisticated. He did his best to respond. He gave his best answers, because that's what he was told by Mr. Kemp to do. At the beginning of the deposition, there were no questions about his health. Even asked, when you do a search of the word index and you look at illness or sickness, it's only in reference to whether or not he knows that Mr. Kemp's clients were sick. Didn't ask what medications he was on, whether it would affect his ability to give that testimony that he gave on that day. We would have preferred to hold off, but I think the court's well aware of the history of how that deposition came about, and it was set every week for, feels like 4 or 5 weeks. And he knew that we needed to get that deposition done. He did his best to give that deposition so that we could move forward with this case. But it would be extremely unfair and prejudicial for the plaintiffs to be able to say that he's a managing speaking agent and therefore a party, and therefore under 32, his depo could be used for any purposes, which would be the opening statement and play clips of, especially him saying that it takes a day to get a negative reading with the meter. I don't even understand that one. It's going to be confusing to the jury. And I'm not saying they can't impeach him with that testimony. They certainly can. He's fair game. But he's not a party for which the deposition should be used for any purpose, and specifically that purpose being sound bites and opening statements. And I think that would be completely unfair, it's inappropriate, and he's simply not a managing agent, he's not an officer, he's not a 30B6, he was not given topics, and he's 2 days removed from being out of the office for 6 months for a very serious illness.
And I just have one question for you, Mr. Robbins. How do I define managing agent under the rule? Because it, we can all agree in this one point, it's, if you look at it, it can be the party's officer, director,
Right.
managing agent, or designee under 30B6 or 31A4.
Right, so the only one that he would qualify for potentially would be the managing agent. I think we would agree on that. He's not an officer, he's not a director. Wasn't a 30B6. So that would be Palmer, which your Honor is well aware of that. And it would be the Palmer test, and generally describing it as somebody that can bind the company. To me, it's somebody that can really call the shots and stuff like that for a company. Not just the guy that's in charge of, responding to a customer complaint over the phone, or making sure invoices go out, or making sure that the tip card's put in the box. I mean, that's what Mr. Brown does. And we've listed, if you look on page 7 of our opposition, and it's at his deposition at page 20, line 20 through 21 through 8, you can kind of see the types of things he does. He says, I learned a little bit of everything. He says, I learned how to receive shipments when they came in. I learned how to, of course, box up orders, do some invoicing, create labels to go on the boxes to ship out. So I learned the in and out aspects of shipping. I did a lot of customer service over the phone. I learned to do certain repairs on some returns that came in. So I kind of learned everything. That's the kind of stuff that Mr. Brown does. He's not the guy negotiating contracts or buying orders or signing lease agreements. He has zero authority to that. He has no idea who the owners of the company are. I think at one point he was asked that question. He's not in the know, he's not in the loop. He took over the job from somebody who was deceased, who I think obviously was more involved with the company. And any serious decisions end up going through Mr. Salvaggio, and he, when and if that deposition 30B6, notice 30B6 is taken, he is going to be the 30B6, and he is the one that the company would designate to speak on his behalf on the notice topics. So under Palmer, I don't think he's a managing agent. He certainly doesn't qualify as any of the others. He's not an officer, director, or was he noticed as a 30B6, and he wasn't properly admonished. I'm not guessing, and difference between guessing and estimate, which there's no requirement for that, but that also, I think, resulted in some of the answers. He's a nice, Southern gentleman, and he was trying to be accommodating, and he tried to do his best, and I think he did. But it would be extremely unfair to say that he speaks for the company or would be in a position to speak for the company, given his background and what he actually does at the company. That's how we respond.
Thank you, sir.
I appreciate Mr. Robbins' comments. I've worked with him a long time, and I like the fact he's very direct. But unfortunately, in terms of this motion, there's a couple of mistakes that I think he's made, not on purpose, of course. But if we could pull back up Exhibit 17. Again, these are the answers to interrogatory, supplemental answers from Milwaukee. If you go to the last page of this document, page 16, not the page 16 of Exhibit 17. Oh, you had it and you lost. Right, no. There we go. Stop right there. Your Honor, this document, which indicates that Mr. Jason Brown is the General Operations Manager, was signed January 13th of this year. So when Mr. Robbins got up and said that he was no longer the General Operations Manager and he'd been demoted, that's not reflected based upon this date. These interrogatories were supplemented. And then when Mr. Robbins said that he didn't know who the owner was, he was so sick, let me go back to the deposition of Mr. Brown, please.
I want to make sure I'm clear. What are you saying, Mr. Parker, as far as signing the interrogatory?
Oh, of course, Your Honor. These interrogatories, of course, are signed under oath. They're sworn to. And the person who signed them and prepared them indicated on January 2000 of this year that that Mr. Jason Brown was a General Operations Manager. So now, can you make that smaller for me, Shane? So, Your Honor, this is what we read from earlier, lines 4 through 13, where he admits that he is the operations manager of Milwaukee Instruments. Later on, he talks about his responsibilities being the same. But if we go to page 24, I believe it's 24, yeah, 24, he talks about his relationship to the president. So a little while ago, Mr. Robbins said he was so sick that he can remember who the president was. He didn't really recall. It says here, do you know someone named Carl Savaggio? Yes, I do. What is the relationship to Milwaukee Instruments? He's the president. How long has he been the president? Since I've been here, as far as I know. And the president, is that the person you report to? Yes, sir, he's my boss. He reports directly to the president of this company. And he's been with this company since 2009. Your Honor, he is a managing agent. When you look at our opposition, our reply, Your Honor, page 4, we list 3 cases here that discuss where people in lesser management positions have been determined to be managing speaking agents. We have the Bay Explorer Inc. versus Pensa Inc., which is an Oklahoma case of 2012. And we have the Reese versus Virginia Intern Terminals case. It's a federal case, 286 FRD 282, which is a 2012 case. Yes, it's 2 cases. Oh, and there's also the Boston case, Your Honor. We also are cited to the Greenspun case, which you're familiar with, the 1975 case. You've seen that one before. Your Honor, the rule does not indicate that you have to have a certain IQ level. It doesn't say you have to have a degree in any particular field. It doesn't say you have to have a certain amount of experience. The rule does not mention any of those things. We've gone over Rule 32A3 several times today. And none of those things that Mr. Robbins mentioned as a concern are addressed in that motion. Because you can select who your PMK is. You can decide from a company's position who you promote to be a manager. After roughly 13 years of working at this company, he became a manager, second only to the president. And given the case law we've cited, Your Honor, and given that the rule does not take into consideration whether someone had COVID the day before, or perhaps a cold or a flu, that position remained the same, his responsibilities remained the same, the title is confirmed in the answers to interrogatories, and as a result, Your Honor, we ask respectfully that the court grant this motion.
All right, I just have a couple of comments before ruling. And if you go back and if you do a somewhat of a deep dive, for example, when it comes to a 30B6 designee, and you look at the history behind the rule, one of the things they talk about was this, and this was the difficulty. You go back 40, 50 years, and you're taking depositions of individuals from businesses and corporations. It was almost like whack-a-mole. You would ask them questions, they said, well, I don't know that, that's such and such's responsibility, and so on and so on. And there's case law that discusses that very principle. Just as important too, if you take a look at Rule 32, and more specifically, 32A3. And it talks about the specific individuals that can be utilized for the purposes of binding the organization in a general sense, right? And one of them is a managing agent. And so I'm trying to figure out why a operations manager wouldn't come under that umbrella of managing agent, right? I mean, because if that wasn't the case, then the only person you could ever depose would be the president.
The president.
Yeah,
That's correct.
right. As far as hierarchy is concerned. And he was in a management capacity. And whether he can explain away or, I mean, I haven't looked at the deposition in great detail, but it appears to me, when you look at the rule itself, and you look at the policy reasons behind the rule, and I think that's important to point out, I can't figure out why he wouldn't come under that definition. I just can't. And so anyway, what I'm going to do is this. And then which one are we on?
Number 8, Sean. Plaintiff's motion on number 8.
Regarding plaintiff's motion, let me number 8 to designate Jason Brown as a managing speaking agent of Milwaukee Instruments. And in light of his capacity as operations manager, I'm gonna have the motion.
Thank you.
So what's next?
Our motion in number 9 is to preclude Hanna and Milwaukee from arguing that we, plaintiffs, have the burden of producing an alternative warning as part of our case in chief on federal warning. And, you know, this has been an issue in this jurisdiction for probably 15 years. Every time we do a failure warrant case, the defendants, Mr. Roberts, for example, jump up and they say, well, Mr. Kemp didn't have an alternative warning. And I say, well, I don't have to have an alternative warning because it's the same as the reasonably dangerous analysis. You know, I don't have to present an alternative design for a car, okay? I just have to criticize your design. And so that issue's been thrashed by the courts for, like I said, about 15 years. And basically the defense always cited this case from Arkansas and this case from Oklahoma saying the plaintiff's burden is to provide an alternative warning. None of that case ever said that, but that was always a big issue. So finally, we had a good case that we took it up on, which is the Chiavani case, which was my case and Mr. Christensen's case. And we got an excellent opinion from Justice Stiglitz. It came out in 2021, and Justice Stiglitz analogized it to the design defect and saying the plaintiffs don't have to have an alternative design. So same thing here, they shouldn't have to have an alternative warning. And the quote is from the opinion, this is the holding.
Page 4?
I'm on page 2 of, well, I'm on page 1 of my reply, but it is on page 4 of the motion.
Right.
First, plaintiffs do not need to provide the jury with a specific proposed warning in failure to warn cases. Unquote. That's not even 2 years old, okay? It's not even 2 years old. And the defense bar says, forget that, we can go cross-examine the plaintiff's expert, and this is what they say they can do. We can, quote, well, pointing out that plaintiff has not presented a suitable, adequate warning themselves, unquote. That is nothing more than an attempt to argue that that's a requirement. It's jury nullification. And so we have a case that's not even 2 years old. And they're trying to ignore the case and argue that we have to have an alternative warning. So, I mean, I filed this motion out of abundance of caution just because of my bad experience in the last 15 years having argued this so much. I didn't think they'd argue that we should ignore Chiavani, but that's what they've argued. And based on the Chiavani case, Your Honor, how much clearer could it be? You know, they can't get up to the jury, whether it's cross-examining my expert, whether it's presenting their expert, closing, opening, they can't say, oh, what the plaintiff has to do is provide an alternative warning. We don't have to do that. Okay? We can do that if we want, but we don't have to do that.
What was the logic behind it? I'm trying to figure it out because, you know, it's my understanding based upon products liability law, the thrust and focus is on the product itself and where it's defective, product and reasonably dangerous, and the inadequate warnings can also be part of that.
Right, it's same defect analysis. Okay,
Right.
so the logic of those cases, they were federal court decisions out of Oklahoma and Kansas. I think that says what the logic was. But, they hung the plaintiff's attorneys out to dry and not have an alternative warning. But those are the holdings of those cases, Your Honor. And that's what we went up to, the Supreme Court went on Kiabani. That's what Justice Tiglich decided. And there was no dispute among the other justices about this. It's not 4-3, and there was vigorous dissent by the 3. I mean, I think it's pretty settled law. And so why they really want to do this, I don't know. But it would be a direct violation of Kiabani, so it should be precluded.
Okay. Mr. Robert, are you, okay, go ahead. Mr. Rasmussen.
That's close enough, you hear me? Yeah.
Oh, I can hear you right now.
It's further I'm more worried about.
Okay,
Sorry about
but if
that.
you want to approach, it's up to you. You can.
No, it's a landmine now to try to get through all of this. I'm not the smallest guy, I'll just put it that way. So I'm just gonna stand back here. That is okay with the court?
That's perfectly fine with me, and ma'am, can you hear him?
Yes.
All right. So I think what I am worried about, and the reason that we filed our opposition is not so much that we don't understand the Kiabani case. We understand that. We understand when it was created. We understand all of that, Your Honor. The problem is that when I get up and ask their social scientist, retired professor from Cal State Irvine, who's never done a failure to warn case in the state of Nevada, nor has he ever been qualified to do so, and in his own deposition said, I've never been in a court in the United States where I've given such an opinion, that one of the questions they're going to say is, you cannot ask him, well, don't you have an alternative? Don't you have an alternative? The reality is I should be able to say that. Do you have any alternative language? Or better yet, can you even give an opinion as to what the alternative language should be, considering your background is not in any way related to the sciences about scientific instruments or what they do or how they behave or anything like that. And that was the concern that I had in
But
this case.
what kind of expert is he? Because I kind of think.
He's a social scientist.
Okay, I
He's
understand.
a retired.
Human factors, right?
No, not human factors. No, he literally does communications books. That's what he does. He doesn't do human factors. He's not an engineer. He's not a scientist. He's not a chemist. He's not a physics guy. He got a degree in
But isn't human
communications.
factors more psychology related and how you read
There's
warnings and
there's
what impact
another
they have?
motion where they specifically challenge his qualifications. That's why I didn't go into it. And I'm not trying to shortcut that motion, but I can go into it.
You can, I'd just like to finish, and then if Mr. Kemp needs some time to interrupt me, then I won't interrupt him. But,
No, go ahead, I'm listening.
thank you.
But tell me this, what's the relevance of an alternative, right? I mean, really and truly, I mean, are we saying this, and this is more a question from my perspective.
Right.
We're focusing on in a strict products liability case, and there's an issue regarding defect. Are you saying that the plaintiff is required to?
No.
You know where I'm going on that,
I
right?
do, I understand that. I'm simply going to ask him, are you even qualified to give an alternative? To which I anticipate the response will be, no, I can't. So if you're not able to give an alternative, can you even criticize what's given? I mean, are you qualified to do that? So I appreciate what they're saying here, I understand the law, but that might be something we have to decide down the road, but this is certainly something I don't want to be limited to at the time of trials, to being able to ask those kinds of questions. With that, that's all I had, Your Honor, on this one.
I'm looking more around.
Mr. Robbins, did you, I don't want to overlook you, sir.
Notwithstanding Mr. Kemp saying Mr. Robbins kind of got to jump up and argue against this, I didn't oppose this motion.
Okay, but I heard your name, I didn't want to,
No offense.
okay. Now, this is what I'm going to do, I just want to make sure I'm clear on this. Number one, whatever decision I make is not going to impact your ability to challenge the credentials of this expert, right? I haven't gotten to that yet.
Thank you.
I have not. But the issue appears to be fairly simple in this respect, is he is the plaintiff's expert in a products liability case involving adequacy of warning required to offer a warning that potentially, in their opinion, would not be effective, or not be appropriate, and so on and so on. And I don't think the law requires, an expert to do that. Because like, if we follow that to the natural ending point, if you have a product defect case, and this is all under product defect, right? Potentially, if there's a design defect as it pertains to gas tanks on Ford Pintos, and the expert comes in and says it's defective because in a 5-mile-per-hour accident it shouldn't explode, is he required to present and engineer an appropriate Ford Pinto? I don't think so. I think all he has to do is point out the defect and so on. And he might be able to say, look, you know what, that 25 cents washer, they shouldn't have used that, and this is why. But that's kind of how I look at it, but that's not going to the qualifications. I think that's what your concern is, and that would be component one, as discussed in Hallmark, right?
Right.
Yeah, okay. Let's move on.
I think the Pinto part was actually an 8-cent part.
Was it 8 cents?
Yes,
Okay, it's been a long time.
Yeah.
I think we studied that in law school, so you can imagine.
1977, Ford versus Grimstad, or Grimstad versus Ford. Your Honor, this has to do with Blaine Jones. So Blaine Jones, Judge, you're granting the motion, correct?
Yes.
Now, with regards to.
You're on number 9?
We're on 10. Now.
10.
Okay, so Blaine Jones, again, you've heard a lot about him already, you give his depositions. So Mr. Jones was the one that made the concentrate. He was involved in the O.J. Henderson. He was involved in the FDA thing. Sometime in October, he went on a hunting trip up in the state of Utah. And when he went on that hunting trip, he took with him, I can't remember if it was 1 or 2, but they were 5-gallon jugs of real water. Up in Utah, he drinks the real water. He gets acute liver failure. He has a real graphic description of how he can barely stomach back to the hotel. And they have to take him down here to a hospital. He's hospitalized 4 days. They tell him he potentially has to have a liver transplant. He goes on and on. And we have a real good description of it because he didn't have health insurance, so he wrote a GoFundMe page. And I must say, he's a pretty good writer. So we've got a 12-page description of his injuries blow by blow. Okay, so this came out during his deposition because we were asking him about probable cases, and he popped up and said, oh, the Southern Nevada Health District told me I'm a probable case. So apparently he's one of the 21 probable cases. I don't know if he knows that for sure, but that was the information he had in the deposition. So at that time, I asked him, well, you're a probable case, and you think you got acute liver injury from real water. And he said, yeah, I think I did. And so I asked the logical next question, well, have you consulted with an attorney about suing real water? And he said he had actually gone and consulted an attorney, and he had decided not to sue real water at the time of his deposition. And this was the second deposition that I think was taken in February of, was it this year? This year, time flies. So it was the second deposition. He hadn't hired an attorney. So great. After the deposition, he did hire an attorney. He went and hired Mr. Christiansen. And Mr. Christiansen, and probably the last suit filed, because I filed one with him, I had a plaintiff to it. We were trying to beat the, there's a big argument about when the statute of limitations starts, it doesn't start. So out of prudence, we take 2 years from the first public report, and in our minds, we count that as safe harbor date. So so I had to get my last case filed, Pete had to get his last file, so they filed the suit. All right, so Mr. Jones, you know, really kind of the definition of karma here, the guy who makes the concentrate actually gets acute liver failure for drinking real water. But he is now a plaintiff as we speak. That's a late filed case. I don't know if it will get a trial date until 2025, 2026. So they filed a motion we filed a motion to preclude reference to the fact he was a plaintiff. And as I said in the motion, we have mixed feelings about it. You know, on the one hand, we can see that there's a big benefit to having the guy making the concentrate say, oh yeah, this real water is bad stuff and gave me injury, and also saying, hey, the meter's bad, you know, because those are the allegations he's made in the lawsuit. So I can see the plaintiff getting a little benefit out of that. They raised the concern, well, Mr. Jones, you know, he's overly sympathetic to the plaintiffs, so that's just because he's a plaintiff, so we should be able to tell the jury that he's a plaintiff now. So what I offered to do to try to cut through this Gordian knot here is I said, I'll just play the deposition. Okay, that kind of limits our ability to present the case the way we want to. I was just going to play his 2 depositions, do some, you know, slicing and dicing of the video, try to do it that way. But I said this in my reply too. I don't feel strongly about this, Your Honor. So if the 4 defendants stand up and say, Judge, we should be able to tell him that, tell the jury that he's a plaintiff, I'm fine with that. Okay, I just want to make that clear. If that's their decision, I'm fine with that. If they want to do it the other way, I'm fine with that too. Okay, but I think we should have some kind of resolution of this particular issue. And I will tell the court, if they take the position that we can tell the jury he's a plaintiff, I'm going to do just what I said I was going to do. I'm going to say, well, here's the guy that ordered and bought the meters, he's the vice president, and he says these Hanna and Milwaukee meters are terrible. Okay, I'm going to do that because now that they're telling him he's a plaintiff, I can do that. So whatever way they want to play it, Your Honor, I'm game.
You guys got consensus on this?
Your Honor,
I'll just listen to everybody.
No,
No consensus amongst the
we do
defendants.
not, Your Honor.
Interesting, this is an interesting issue.
I don't think it surprises you, but Real Water filed a motion limiting number 5, I believe, and part of the requested relief was to exclude the Blaine Jones lawsuit. And so we are taking a consistent position. We think this motion should be granted, and we think our motion should be granted, and this lawsuit should be excluded. It would result in a mini trial over Blaine Jones' own personal lawsuit. That is filed in front of a different judge. Don't even think it's been served yet. Don't even think the bankruptcy stay has been set aside. And so that case is going to go its merry way and should not be part of this case. And it's just going to be more prejudicial than probative. Certainly, the plaintiffs have asked Mr. Jones, and he's testified as to his illness. At the time, he didn't know he was sick from real water, and he'll testify to that as well. And he will testify truthfully as to all the things that happened to him in graphic detail. And there's no dispute over any of that. The problem is it's prejudicial then to take the next step and say, oh, in fact, you're suing your own company. That just is one step too far.
Okay, thank you, sir. And ma'am.
Thank you, Your Honor. And our position is that we know he's going to come live to trial. Mr. Odou said he's been served with a trial subpoena. And we have his testimony from the depositions. At the very least, there should be an ability, depending on what he says, as compared to his deposition testimony, to impeach him with this. But I think it is relevant as to bias. We can certainly wait until trial and let the parties know if we intend to introduce it. But I think that, I don't think it should be precluded before we hear what he has to say on the stand.
Okay, ma'am. Interesting. Thank you.
I'm going to agree with Joan on this one. Skyrock Slump and instruments. I think that's exactly what we need to see is whether we have the opportunity to impeach him at the time of trial.
And so you agree with, is Ms. Anderson, right?
I do agree with Ms. Anderson on this.
Okay, just want to make sure.
There's one part in his depo that I remember, second depo, he said, you couldn't give me $10 million to go through what I went through. And I thought, boy, that's an odd thing for the guy from Real Water to say on the stand.
Right.
Okay, now I kind of know why he said it, you know? It goes to bias, you know, he's setting up his own claim, the guy's dirt poor, doesn't have health insurance now, you know? That's where all this crap's coming from. And I don't care if he wants to put in what Mr. Jones said about the meter, he likes our meter. He said, good, he might change his testimony at trial, but now I know why. He's got a financial motive, it goes to bias, so it has to come in.
Just to correct the record, and I apologize,
Well, that's
Mr.
okay.
Robbins, he had asked me what he said, and a hard of hearing. What the question was, he said, I went through hell and back. And Mr. Kemp said, you wouldn't do this for $10 million, would you? And he agreed with Mr. Kemp. So it was actually Mr. Kemp putting words in Mr. Jones' mouth, just so the record's very clear.
Like I said, I don't care, just tell me what the rules are, but I don't think you can wait until he takes a witness stand for a couple reasons. One, I've got to plan my strategy here. So if they're potentially gonna say, oh, disregard everything he says, ladies and gentlemen, he's the plaintiff now, I have to diffuse that during the opening statement. So I need to know where we're going. And like I've already said twice, I don't really care, you know, the votes, I guess 3-1 over there, if I'm counting right, maybe it's 2-2, I don't know. But I think we need some kind of ruling. I don't know if the court wants to think about it.
No, I really, unless it's something I really want to contemplate, this doesn't happen. Like the first one I took under advisement, I do want to look at remember I asked for the transcript and all that, I do want to look at that. I'm looking at this one from this perspective because, and I'm not making this decision solely based upon, truth, because sometimes, you know, depending on what the statements are, what the truth is, doesn't always come in. But I'm looking at it through this lens. I mean, ultimately, if he is a plaintiff, he is a plaintiff, right? And so, potentially, that goes to motivations, basis for testimony, and those types of things. And I think under those circumstances, and understand this, I'm not dealing with, I understand, Mr. Odou, you have another in limine coming up regarding his testimony. So I'm not making that decision right now. That one there, I might have to think about it, I don't know. But I think what I want to do is this. Plaintiff's motion, limiting number 10, to preclude reference to the fact that Blaine Jones is now a plaintiff. I'm going to deny that. I'm going to just let it is what it is. He is a plaintiff. And it really comes down to, for example, if he has financial motivation, we should be able to kind of go into that. And I'm not going to hamstring him from the cross-examination.
If they call him, it'll be a direct examination, so
Yeah, I
that's a whole other issue, whether they can introduce bias on their own witness.
Well,
If I call him,
Yeah, well, I understand, I do. That's something we'll have to deal
you
with.
can call him, but I don't know.
He's not our witness.
Yeah, I mean, I don't know, but he's a plaintiff, right?
Right.
Yes, he is.
Yeah, and so, and that one I didn't want to, I have enough to contemplate. I have to go back and figure out what I gotta get done, so. Actually, maybe we have time today. Where do we go next?
There's a motion to strike UNFI's answer that we should take up, Your Honor. I would ask,
Okay, we'll go there. Which one, and that is that plaintiff Haley and Belsky's motion to strike UNFW's answer for creating and using fake Whole Foods records.
it is, Your Honor, although I object to the court using that caption.
I'm just reading.
I understand, I'm giving you a hard time. I would ask if the court doesn't mind that we take a very brief recess to use the facilities.
Absolutely. Let's take 10.
All right.
Thank you.
Thank you, ladies and gentlemen. Part 6 meeting will now come back to order. Please be seated.
Thank you. We're back on the record. I guess next up would be plaintiff Haley and Belsky's motion to strike UNF answer and for creating and using fake whole food records, is that correct?
That is correct, Your Honor. This may take some time, Your Honor.
Oh, yeah, I anticipate.
Okay, good. And Your Honor, you're familiar with the cases, but just for purposes of the record, I would suggest that the cases that are most applicable today in terms of this motion will be Young versus Johnny Riviero case, which is a Nevada case in 1990. The Bass Davis case, the Stubley versus Big D case, Clark County School District Richardson case, 2007 case, Valley Health System versus the State of Doe, 2018 case, in the Direct Rating and Paving LLC versus 8th Judicial District Court, 2021 case, the Levitt Seams case, which is a 2014 case, and the Rahina versus Goodyear Tire and Rubber case, which is a 2010 case. All of those cases have been cited, and if not cited, Your Honor is very familiar with these cases. And in terms of the Young Riviero case, and the cases that have come after that, a motion like this, where we're seeking what some would consider draconian sanctions, requires an evidentiary hearing. So I will say up front, Your Honor, we believe that we're going to put enough information before the court today to warrant an evidentiary hearing, at which time we're going to ask that the court allow us to bring certain witnesses to the stand so that the court can get a full understanding of the rule violations that have been committed by UNFW. If for some reason we do not seek a motion, a striking of the answer, a lesser sanction would not require a evidentiary hearing. And I say that because of the Clark County School District Richardson case. That case started out with a request to strike, but during the evidentiary hearing that was held, Judge Levitt decided to strike the affirmative defenses. That case went back and forth to the Supreme Court. In fact, I tried that case. And all of the affirmative defenses were struck, as well as the experts for the defendant in that case. And Justice Hartstein indicated during an oral argument that perhaps the judge should have struck the complaint, because it's so difficult at times mitigating between striking the affirmative defenses versus striking the complaint. In this case, Your Honor, we are seeking that you strike UNFW's complaint. And we believe that an evidentiary hearing will be necessary given the information we have. Your Honor, I was somewhat surprised by the opposition in this case, and especially the affidavits that were submitted with the opposition. Your Honor is familiar with Rule 16.1 and is familiar with the fact that 16.1 requires initial disclosures, it requires supplementation of disclosures, it requires disclosures pre-trial, and it requires disclosures in terms of your experts. We believe that every portion of 16.1 dealing with disclosure requirements have been violated by UNFW. And we believe that UNFW, unfortunately, and its counsel have been complicit in withholding purchase data and instead providing what Mr. Kemp has described as fake documents as a part of their disclosures, which were done untimely, done strategically right before depositions, and utilized in several depositions in a way to coerce or cajole witnesses to say things that were simply untrue, or try to convince them that their recollections were false. They were given to experts in an attempt to malign expert reports. They were used in expert depositions in an attempt to, again, perhaps change or taint the expert's opinion. Your Honor, what we have here is a violation of Rule 16.1A1 because the purchase data from each of the stores should have been produced, and it wasn't. And we have an admission of that now in the form of affidavits, which we'll go over. We believe that these Excel spreadsheets are nothing more than a compilation of information decided to be produced by lawyers in an attempt to steer or direct the testimony of witnesses in preparation for trial. That's what we have. Now, let's give the benefit of the doubt to the lawyers in some respect. Let's say that they were simply relying on information that a non-party to this case provided, despite the fact that these lawyers also represent that non-party Whole Foods. They received information that they themselves knew were spreadsheets. It appears that they never asked for, and certainly, I assume, never received, because of course they would have had an obligation to produce that. They never produced the raw data. And to this day, we don't have the raw data. What we have is spreadsheets created through search inquiries done by an Amazon employee exclusively dedicated to Whole Foods to provide information he derived from his search using an SQL search. That's what we have. And I think all three affidavits prove that. So question number one, why didn't UNFW provide the raw data for the lone Whole Foods in Reno, the Fort Apache store, and the Lake Mead store? We have no reason for that. There's no reason in the opposition. What we have in the opposition is an affront to this court. It's an affront to our rules. It is, there was no violation. That's what you have in the form of an opposition. What you don't have is the raw data. You don't have an indication that the raw data is available to be inspected. You don't have an offer of the raw data being available for inspection. So let's consider the folly of UNF's position. Your Honor, you're familiar with the rules of evidence in Nevada, surely. And I know you're familiar with Rule 52, NRS 52, not the rule of the statute. NRS 52.275 deals with summaries. And Your Honor is very familiar with that, because we've had so many construction cases where we've tried to summarize documents, have our experts summarize documents. And what do? Typically, these summaries have, in the form of the chart, the actual date numbers of the documents being used to support the summaries. Because as you know, and every lawyer I believe in this room should know, summaries are only allowed if you have the backup documentation and you've provided it to all counsel. And this is what it says, NRS 52.275, the title of it is Summaries. Paragraph 2 says, the originals shall be made available for examination or copying or both by other parties at a reasonable time and place. The judge may order that the originals be produced in court. That's paragraph 2. Paragraph 1 says, the contents of voluminous writings, recordings, or photographs, which cannot conveniently be examined in court may be presented in the form of a chart, summary, or calculation. Paragraph 2 puts the onus on the company or the party attempting to use a summary to actually produce the raw information. It should have been produced pursuant to 16.1. And it wasn't. It simply was not. And so, Your Honor, when you consider the fact that the raw material was never provided as an initial, as a supplemental, as a part of an expert file material, and then ultimately 30 days before trial or the close of discovery, none of that's been done. And we know it has infested this case. Our motion, I'm not going to read over the motion or the reply verbatim, Your Honor, you've read it. But our motion points out that UNFW used this Excel sheet or spreadsheet in the deposition of Mr. Belsky, Mr. Haley, two plaintiffs, our expert, Dr. Freeman, our other expert, Dr. Hudson, also gave it to their own experts, It's too late to clean or correct those problems. Can't redepose them. It's too late for that. Every part of the discovery has been affected by their failure to produce the raw data. Now, we have here, Your Honor, I believe we have this available to us on the overhead, to make sure. You have this, correct? I talked to you about it yesterday. UNF's attorneys provided supplemental responses to the plaintiff's second set of request for production of documents, request number 11. I think Shane has it on the screen now, Your Honor. Now, I want you to consider this, Your Honor. I don't know how many times Mr. Neale has said this, or Ms. Anderson has said this, but I know between the two of them, they've said it more than twice, that they do not represent you, they don't represent Whole Foods. And Whole Foods is a non-party. When I say they don't represent Whole Foods, not in this case. But they use that as a shield to say Whole Foods had no obligation to produce the 16.1 information. Whole Foods had no obligation to comply with 16.1. So let me show you how they hide behind this. If you could, Shane, let's go to page 3. Request number 11 says, please produce the itemized transaction history related to Keith Haley's purchases with either his credit, debit card, or with his employee discount card from January 1st, 2018 to December 30th, 2021. Now, certainly, given everything you've heard up to now, Your Honor, you know how important it is for us to demonstrate exposure to the toxic, exposure to this adulterated product, or if you want to say the defective product. So their response is, they have the objection in the beginning, the first sentence, and it says, in particular, plaintiff Keith Haley alleged in this action, stated in his sworn fact sheet in his deposition testimony, that his claims against UNFW are based on purported purchases of retail water from Whole Foods in 2019 and liver injury occurring in 2019. Whole Foods produced Mr. Haley's entire purchase history from all of 2019. That's what's said here. You know, so someone's making a representation that Whole Foods produced Mr. Haley's entire purchase history from all of 2019. Not a spreadsheet, but all of his entire purchase history. Then it says UNFW objects that Mr. Haley's purchase history from 2018, 20, and 21 are neither relevant to the claims or defenses in this action, nor likely to lead to the discovery of admissible evidence. Well, the Discovery Commission doesn't like those types of objections, but then it goes on. UNFW further objects because the requested documents are not within the possession, custody, and control of UNFW. So when I read that, it made me question, how can counsel for UNFW get 3 affidavits from attorneys aligned with or employees aligned with Whole Foods to provide Excel spreadsheets using customized SQL queries, but yet cannot provide the raw data? Still boggles my mind. Plaintiff Keith Haley has not provided credit card information that would allow a retailer to pull any itemized receipts, and UNF does not have access to Whole Foods employee purchase data. Your Honor, right there. This one sentence is enough for an evidentiary hearing. How can attorneys whose offices represent both Whole Foods and UNFW claim not to have access, custody, or control, or the inability to provide the purchase data, and yet provide an Excel sheet that they claim to be the actual purchase history? That defies logic. It completely defies logic. that purchase data from each one of those stores should have been provided. And it wasn't, and it hasn't. And there's no excuse for it. And it has corrupted this entire case. Now, then it goes on to say, therefore, UNFW does not have any documents responsive to this request. Again, I don't know who prepared that, but how can you say we have the Excel spreadsheet showing all purchase history in the one hand, on the other hand, say we don't have documents responsive to this request? Where's the truth? Where is the truth? You cannot have both. It's irreconcilable, these positions taken in this one response. Finally, subject to and without waiving said objection, UNFW has relayed this request to Whole Foods and will upload any non-privileged responsive documents if and when they are provided by Whole Foods. That's the response, Your Honor. And in Mr. Kemp's words, or Dr. Goldsmith's words, the smoking gun when it comes to an evaluation of this motion. Go to the next page, please, Shane. Subject to and without waiving his previously stated objections, UNFI refers plaintiff to these documents. The documents produced to the HOLO repository, and it's Whole Foods 641. Now, this is what Mr. Kemp raised earlier when he said on Monday, the fake Whole Foods documents. We're using Whole Foods prefix as a big stamp and putting 641. Except the paragraph before it said they had no access to Whole Foods documents. So in reality, that spreadsheet, Whole Foods 641, should have been UNFW 641. Because it wasn't Whole Foods, but they have no access to Whole Foods. They're going to pass on the request to see if they can get a response from Whole Foods, which contains the itemized transaction history associated with Keith Haley's employee identification card for all transactions occurring January 1st, 2018 through December 30th, 2018. And the documents, the in-store purchase of one 500 milliliter bottle of real water on March 5th, 2018. Now, during the deposition of Mr. Haley, and this, by the way, this is signed, Your Honor, June 21st, 2023, roughly 2 months ago. No, 1 month ago. So, in the discovery, the deposition and the damage has been done, and that's the response we get. So we know based upon this document that there's in-store data that we haven't received for at least the 3 stores that are mentioned. And we know we have not received Whole Foods documents, the purchase information contained either in a warehouse, which is mentioned in the affidavits that we'll go over in a second, or somehow else stored electronically. We know we don't have that information because all we have is roughly 10 pages of Whole Foods documents. Your Honor, I have the actual affidavits, and I'd like to go through these affidavits with you. They're attached as Exhibits A, B, and C to UNFW's opposition. And let's start with Exhibit A. And this is the affidavit of John Hempling. So Mr. Hempling, Your Honor, he signed this affidavit in support of UNFW's opposition to motion to strike. And we go to the last page. Thank you. You're already there, Shannon. Thank you. It's July 14th, 2023. So about 2 weeks ago. And we go to page 2 of this. John Hempling introduces himself. Mr. Hempfling is a graduate of the University of Texas at Austin and the South Texas College of Law in Houston. He's a member of the Texas Bar and employed as a vice president and associate general counsel litigation for Whole Foods Market Services, Inc. And I stress Whole Foods because it appears to me, based upon this paragraph alone, that UNFW's current counsel has access to Whole Foods counsel, associate general counsel. Now, Your Honor, I know that UNFW has lawyers licensed here and lawyers that admitted pro hoc here, I believe. And certainly this court is very familiar, because I don't know how many times I've heard you stress this over the many years that you've been on the bench, Your Honor. Our rules of professional conduct. Rule 3.3 is candor towards a tribunal. Rule 3.4 is fairness to opposing party and counsel. These rules stress how you're not supposed to do things that would otherwise taint, infect, corrupt this process, be it before your honor as the tribunal, or between a party like Mr. Haley, or opposing counsel like Mr. Kemp, Mr. Pepperman, and myself. It's my belief, it is our position, that UNFW has done just that. It has pretended to provide documents from Whole Foods that are simply a compilation of spreadsheets created for litigation that was asked by counsel for UNFW to counsel, Associate General Counsel for Whole Foods. Now, paragraph 3, Mr. Hempfling tells us, Whole Foods maintains point of sale data in the ordinary course of its business. A business intelligence engineer can query the Whole Foods warehouse sales data to identify purchases that fit specified search parameters and report that data in an Excel spreadsheet. Your Honor, if there's no more telling statement than this one in terms of Mr. Hempfling's assistance to our motion, I thought for a second there, this affidavit is being provided to help us win this motion, because he has now separated sale purchase data from a specified search SQL query in an Excel spreadsheet. We didn't ask for Excel spreadsheets. We asked for data. That's what's required. That's what's required from our rules. You don't get to use a spreadsheet without producing the data, original data. And if you're doing electronically native data.
I mean, I get that, and it's actually more complex than even that, because, for example, and this comes up all the time in business court, if we have issues like this, we have to agree to some sort of appropriate ESI protocol.
Absolutely.
To do research, and just as important too, sometimes those are not as effective as we anticipate, and they do another one. I mean, this happens quite a bit, but do we even know what the ESI protocol was?
You're ahead of me. I appreciate it. Let me get you there, Your Honor. But we had no ESI protocol. There was no agreed upon SQL language. And Your Honor, you've handled some of the biggest, not just business court cases, but before that, the dirt court cases, where we've had thousands of homes, and we were searching for information from builders, subcontractors, that we put into spreadsheets. But we had agreed upon SQL language even back then. There was no agreed upon SQL language, and on top of that, which is, you'll see this later, they removed the SQL language in the tab, so we don't even know the search parameters. That's going to be borne out in the affidavits. This is one of the worst examples of how you do not comply, or I guess one of the best examples of how you do not comply with 16.1. But he tells us right now, search data in the ordinary course, we've never gotten back. And he tells me that he used, which you'll hear from Mr. Craig Shank, he used his own SQL parameter, didn't inform us of that, in fact kept the SQL language because they considered work product. And yet we're supposed to rely upon that spreadsheet, that Excel spreadsheet, as the sale purchase data for each of these stores, for each of these plaintiffs, for all the purchases over 3 years. Now, we go on. Paragraph 4. Joan Anderson, I believe that's Ms. Anderson sitting here, is counsel of record for Whole Foods in the real water litigation. Again, that amazes me that we have this admission in this affidavit, this Ms. Anderson is counsel for Whole Foods in the real water litigation, and yet in the previous answers to interrogatories, they had no access to Whole Foods records. Again, the disconnect is unbelievable. And it says, she routed 7 requests for Whole Foods purchase data. And that I understand relate to the Gallagher versus AffinityLifestyle.com Inc. et al. Case. So apparently Ms. Anderson sent 7 requests. Now, we don't know what happened in the communications between Ms. Anderson other than this paragraph, but what we do know, if she sent 7 requests, why didn't we get 7 responses with real purchase data responding to those 7 requests as opposed to an Excel spreadsheet? Because that's what we're entitled to under Rule 16.1. And then he says, although Whole Foods is not a party to this case, I endeavored to have Whole Foods provide responsive data. Now that's something that should have been done initially. Whole Foods provide responsive data, not Excel spreadsheets, data. But it wasn't. Now, let me also bring this back to 16.1 for a second, Your Honor. 16.1 requires you to provide information that you're going to use in defense of claims, if you're as a defendant. They're using as one of their main defenses the lack of exposure to the toxin, to the hydrocene within the retail water bottles created by Real Water. That's UNFW's main defense. If you're going to use that as a defense, under 16.1, your initial disclosure requires you to produce it, which means we should have had that from the beginning, long before depositions were taken. But we did not. In fact, you're supposed to have it so you can then formulate your discovery, your written discovery. Again, we did not. So paragraph 5, he says, I relayed each of the 7 requests for purchase data, not Excel spreadsheets, that I received from Ms. Anderson to Craig Shank, a business intelligence engineer employed by Amazon.com Inc. He works exclusively for Whole Foods Inc. Now that's the person I mentioned earlier before I pulled up this first affidavit, John. Paragraph 6. Mr. Shank provided me spreadsheets that itemized data responsive to each 7 requests. This is where it gets fuzzy. I understand that 4 of these requests concerned Whole Foods purchase data with Keith Haley, a Whole Foods team member or employee. 3 of the requests, as I understand it, relate to Whole Foods customer, Mr. Richard Belsky. 2 plaintiffs in this case who are the most concerned for UNFW because they would have gotten the retail bottles as opposed to the 5-gallon jugs. Now, if you can query the information, it means the information is there and available to you. You have an obligation to provide it in electronic format, in a printed format, but in some format. Or if it's too voluminous, under Rule 35 or Rule 16.1, you can offer the opportunity for us to come and inspect. None of that was done. Paragraph 7 says, each spreadsheet reports Whole Foods purchase data that was collected contemporaneously with purchases in question. None was created by counsel. Now, this makes no sense. And this is where I would love to have Mr. Hempfling on this stand explain this paragraph. This is why the evidentiary hearing, which is discussed in the young Johnny Riviero case, is so important. We already know from his paragraphs above that the requests were from Ms. Joan Anderson. None was created by counsel. So, what he's saying is, little word game, Ms. Anderson didn't create it, or Mr. Neale didn't create it. I created it, or had someone create it for them. Again, not a contemporaneous business document, a document generated for litigation, because the attorneys asked them to do it. And look where it comes from. Reports of Whole Foods purchase data. Again, the The spreadsheet is made after the fact. It's not contemporaneous, which means it's not a business record, which means it normally doesn't come in, which also means under Rule 50 statute, NRS 51.275, it's a summary that doesn't come in. The other thing, Your Honor, you need to know, and you'll see again, he now, put that back where it was, Shane, please. Paragraph 7, page 2. All right. Which, okay, I like the other way, Shane. Put it back the way you had it. Don't, that's good right there. Don't move. All right. Which also tells you in paragraph 7 that this SQL is the approach that's being used. They created some search terms to find this information. We don't know which search terms because they consider the search terms attorney word product. Your Honor, if they're going through the process of creating search terms that they will not disclose, which have not been agreed upon, to create spreadsheets from data that is available, that is a complete admission that they violated Rule 16.1. All right, paragraph 8. Before relaying the data to counsel, I reviewed each spreadsheet that Mr. Shank provided me. None of the first spreadsheets showed any purchase of real water. I authorized counsel for UNF to produce these 3 sets of Whole Foods purchase data in this litigation. He authorized counsel for UNFW. He's making a decision what we get to see, or what counsel for UNFW gets to see, and then derivatively what we get to see. In this litigation, not as a part of original data production, but based upon a request from counsel, he created this spreadsheet that he's going to give them authority to release. No appreciation or consideration for our local rules. I understand this data has been produced in the Gallagher case as native Excel files. Your Honor, we've never received native purchase documentation. We received a spreadsheet created for counsel that they provided to us. That's it. And those are the only pages. 8 pages of documents. From 3 years of 3 stores worth of purchase information. Going to paragraph 9. Your Honor, I'm not going to read through the entire paragraph. What's important to me is it's clear now that from January 1st, 2018 through December 31st, 2021, that the spreadsheet, in their opinion, using his employee discount card, showed 1 purchase March 5th, 2018. What it does not reflect are cash purchases without the use of the employee discount card. And you'll learn that from Mr. Shank's affidavit, Your Honor. So, if you want to distort a case, if you want to shake a plaintiff's recollection, someone who's never been deposed before, someone who doesn't have the ability to remember what he purchased 3 years ago, I would hate for someone to ask me what I had for breakfast 2 weeks ago, much less how often I bought water during my breaks at Whole Foods. And I thought about this as I was considering why this is makes such an impact on someone being deposed. I mean, we do depositions every day, hundreds of depositions we do in a year. And for someone sitting across the table from a lawyer, who perhaps did not have the benefit of undergrad, law school, looking at suits and repeats of all CSI movies, you're not familiar with the rigors of a deposition. When you have someone as formidable as Mr. Neale across the table from you saying, our history doesn't show you buying any product. We got the spreadsheet, we got the Whole Foods data. And he's trying to recollect because he just can't remember. He's doing his best. But when you have that piece of paper in your hand, waving it about, it can affect, it can demean, it can seem condescending. And this guy, Mr. Haley, he did his best. But what we don't have, and he said, I didn't buy bottles of water every time with my card, or I didn't buy it all the time with my credit card. They have no reflected purchases with cash considered in any of these affidavits. And you know why we can't counter them? It's because they refused to provide the data in violation of Rule 16.1. Paragraph 10, Your Honor. Again, I think it's clear that the purchase data has not been provided, and I will go towards the end of this page, end of this paragraph, I'm sorry. It says here, I have reviewed my emails and confirmed that I did not provide that Whole Foods purchase data to counsel until June 21st, 2023, 8:57 p.m. Your Honor, we are done with all the depositions by that time. The damage has been done. There's no way of cleaning it up. The bell has been rung. There's no way of unringing it. It's done. And they've been able to use, as a sword, their violation of Rule 16.1. The plaintiff's motion to strike makes clear that counsel for UNFW produced that data the very same day that I provided it to them. That's what they're saying. Now, I love the fact that they say, or he says in this paragraph twice, provided the purchase data. A complete misrepresentation. We still don't have the purchase data. Go to paragraph 11. Paragraph 11 towards the end, Your Honor, says, last sentence says, the data at Whole Foods 181 and Whole Foods 636 through 641 is Whole Foods purchase data that I provided UNFW's counsel of record and authorized to be produced in this case. They keep saying in this affidavit data as opposed to spreadsheet because they know the difference between the two. Now, finally, paragraph 12, last sentence says, it was not collected. This is their attempt to get that Excel spreadsheet in the record, in this case, as a business document, and as an exception to the hearsay rule. It was not collected or recorded for purposes of this litigation. That is hilarious. He says in the beginning, I was asked by counsel to provide this information for counsel in response to this opposition to this motion. This was not only done for litigation purposes, but it was done to try to defeat a motion to strike their answer. It couldn't be any more obvious. So that's the testimony. Now, what I thought, Your Honor, before we go to the next affidavit, what I thought was glaring was Mr. Neale's arguments on Monday. I think it was Monday. The days starting to kind of roll together, Your Honor. But Mr. Neale said, and I believe this is a response to something that Mr. Kemp said. He said, if I had, see if I can, I'm not a good impersonator. He said, if I had this information, I could have questioned no, I know what it was now. It was talking about Sarah Sandstrom. And Mr. Neale said, if I had known about Sarah Sandstrom's declaration, I could have prepared her. I could have gone through the purchase documents. I could have gone through and got her ready for that deposition if I just had that declaration. Your Honor, just think of what we could have done from a discovery standpoint with our experts, with our witnesses, if we actually had the purchase data from day one. Or 14 days after the 16.1 early case conference, or in this case, with the meeting with Special Master Hale. Imagine what we could have done if we actually had the data. But we didn't. And they made sure we did. It was a deliberate act, one that requires address. And I was taking notes down when Mr. Neale said what he said because I knew it would come back to be useful in this discussion. If you could bring up Exhibit B to their opposition. This is the affidavit of Ms. Joan Anderson. Now, Ms. Anderson's affidavit is not as long, but we know that she is an attorney. We know she's been admitted pro hoc vicee, which means she has an obligation to familiarize herself with our rules, both our rules of professional conduct as well as our rules of discovery. And we know now that she represents Whole Foods and she represents UNFW. And so it begs the question, if you can get Excel spreadsheets, you certainly can get purchase back. If we go to her, to paragraph number 1, she says, I am admitted pro hoc vicee in the present case. I am one of the attorneys for UNFW, Inc. in this matter. In addition, I am one of the attorneys representing WFM, which is Whole Foods Market, Nevada, Inc., in other cases alleging personal injury from consumption of real water. So perhaps that introduction explains her connection to Whole Foods and to UNFW, and a representation of both. She goes and she tells us up front, I submit this declaration in support of UNFW's opposition to plaintiff's motion in limine number 16. So this is being used not only for MIL number 16, but also attached to their motion to strike, opposition to our motion to strike. I have personal knowledge of the facts set forth below, and if called as a witness, I would competently testify thereto. This sets up the evidentiary hearing we're asking for. Number 3, I personally assisted in the collection of data from Whole Foods related to the purchase histories of plaintiffs Keith Haley and Richard Belsky in response to requests transmitted by plaintiffs. Now, she says the collection of data, not the preparation of Excel spreadsheets. And I want to continue distinguishing between the two, because we didn't ask for Excel spreadsheets. We're entitled to the raw information. We're entitled to the data. One thing that was done during Mr. Haley's deposition that I didn't understand the importance of it at first, I understood why it was being used, but did not understand it more pointedly until I saw these affidavits. During Mr. Haley's deposition, and even during some of the arguments of counsel, he kept driving home, Mr. Haley doesn't have any receipts, no paper receipts, proof that he purchased real water. Now I learned through these affidavits, Whole Foods doesn't have any receipts. It's so easy to point that finger at somebody and say, well, you don't have anything to prove, any way of demonstrating your exposure to the toxin. Whole Foods doesn't have any paper documents, no receipts. But what they do have is the electronically stored information that they could have provided to us so that we could evaluate for ourselves and our experts could evaluate the exposure and the consumption of real water. And she says that the requests were transmitted by plaintiffs. So this is a discovery effort, as opposed to a 16.1 production. Upon receipt of each request for purchase history data, I transmitted the request to in-house counsel for Whole Foods. I'm not sure who in-house counsel for Whole Foods is. I guess we could learn that during the evidentiary hearing, because I'd love to get that person on the stand so we can find out the communications between Ms. Anderson and that in-house counsel. Paragraph 5 says, once each request has been processed, I received from Whole Foods an Excel spreadsheet. Now, I will say, Ms. Anderson tells us right here, she asked for data, it appears, but she got Excel spreadsheets. Now, I would think at that point, if you ask for data, you would go back and say, please provide me the data. Not the Excel spreadsheet that you created through some parameters that you created through an SQL search. That's not what she got, apparently. Containing data that I understand to be purchase history. Now, this is the condition. She puts a condition and a caveat in this by saying that I understand to be purchase history. Not taking a definitive position on it of each plaintiff based upon the information provided to us by plaintiff's counsel. So perhaps she didn't understand it to be the data, or perhaps she did. That's something that we can figure out, of course, on the stand. Paragraph 6 says, each purchase data spreadsheet I received also contained one or more tabs containing query language applicable to the request. This is what I mentioned to the court earlier. These tabs labeled SQL did not have any purchase history data, but rather a listing of categories and what appeared to be some code. We don't know that, John. That has not been fleshed out, has not been provided, has not been volunteered. So we have no understanding of the parameters of this search, because the SQL language has not been provided to counsel. For each purchase data Excel spreadsheet I received from Whole Foods, I saved the file to my firm's computer system and renamed it in a way that would make the document easily identifiable upon production. For 2 of the files I received, eventually produced, we went through the numbers before, I also removed, this is what I said earlier, I also removed the SQL tabs. Structured query language, which I understood at the time to be work product and which does not contain any information responsive to the request for data. Again, Your Honor, making it impossible for us to determine how this Excel spreadsheet was created. One created for this litigation, one based upon a request, because what we know now through this amount of testimony, through these affidavits, these Excel spreadsheets were not contemporaneously made at the time of purchase. They didn't have a spreadsheet from 2018, 19, 20. These were done after the fact, after the initiation of litigation. And again, she indicates here, I did not contain information responsive to the request of purchase data. Your Honor, I don't know how, after signing this, Ms. Anderson did not understand, or Mr. Neale didn't understand, or UNFW didn't understand that under Rule 16.1, we are entitled to the data, not their decisions on how to create parameters to provide us electronic information that they believe they want to provide. That's not how it's done in the back. And number 9 says, at no time did I ever amend, modify, delete, or alter whatsoever any data in the purchase history spreadsheets we received from Whole Foods. I have no reason to believe that Ms. Anderson corrupted the native data. We have no way of knowing that. But what I do know is this admission is, from this affidavit, is that we got an Excel spreadsheet and not raw data. Exhibit C, please. Your Honor, we've been going a little while. Can we take a quick 5 minutes before we go through C? Because this one's a little longer. It's actually 7 pages, no, 9 pages long. So it's going to take a second.
You guys don't mind, do you? Okay. Let's check with my staff and they want to take me. We'll take 10.
Thank you.
Thank you, ladies and gentlemen.